although the learned judge has given a concession to me.
He says it's
But it's contrary to law. He gives a concession to me. Look here, you don't worry. I will look into those things also. No, he can't do it. When once a new trial takes place, whatever that has been recorded earlier, including the evidence, gets wiped out. That would cause prejudice to the accused.
Recall or resummon?
No. This is the language that is used is,
yes.
Have a look at.
Yes, sir.
Whenever a charge is altered or added, that is what your lordship would find under section 216 subclause 3, yes, as well as under section 216 subclause 4.
Yes.
Here is a case of either alteration of a charge by way of addition or alteration independently. Whenever a charge is altered or added to by the court, after the commencement of the trial has commenced.
Yes.
Charges are altered either by way of addition or by way of subtraction. The prosecutor and the accused shall be allowed to recall witnesses, recall them, continue to record further evidence, if any, vis-a-vis the additional evidence, as my lord has pointed out, which the new investigator would collect during the course of the further investigation of the case under section 173(8). Come on, examine them.
Yes.
To recall or resummon and examine with reference to such alteration, or addition, any witness who may have been examined, unless the court, for reasons to be recorded in writing, considers that the prosecutor or the accused, as the case may be, desires to recall or re-examine such witnesses for the purpose of vexatious delay and all. I have no objection. I would never object. I have not objected. Come on, examine them, recall them, make an application. Look here, some additional supporting.
So the crux of the submission is, what is open is 217, not 230 and 231.
That would be my first submission.
Yes.
My lord, if it is 230 and 231, I shall take your lordship to a couple of judgments of the Supreme Court. My lord, what it says is, if it is a case of new trial, if it is a case of fresh trial, if it is a case of retrial, if it is a case of de novo trial, my lord, the effect is whatever the proceedings that have been recorded gets wiped out. Totally it gets wiped out. I can't place reliance on, although the learned judge has given a concession to me.
He says it's
contrary to law. He gives a concession to me. Look here, you don't worry. I will look into those things also. No, he can't do it. But he can't look into it. When once the law laid down by the Supreme Court as well as by this court and various other high courts is that when once a new trial, new trial is fresh trial, de novo trial, retrial. But when once a new trial takes place, whatever that has been recorded earlier, including the evidence, gets wiped out. That would cause prejudice to the accused.
No, but that is not in a proceeding pursuant to 2164 or 217 or 230 or 231.
I shall take your lordship.
That is in an appellate forum when it is ordered for a new trial, the entire thing gets
my lord.
Or even under 214.
Yes, I shall take your lordship. Even under 216 also I shall take your lordship to that.
Then that is beneficial to you. Then
yes, certainly, my lord. I shall take your lordship to that.
No, that finding appears to be beneficial to you.
Obviously. My lord, may I just request your lordship? Well, the first judgment, and the point the other day, I drew my lord's kind attention. Good. Please give it. I may not trouble your lordship much on this.
Yes, sir.
But this is a full bench judgment of the Supreme Court. But may I just request?
Under 386.
But that is almost analogous. Here also the same thing. There also.
That is what I asked. Yes. Under 386, everything gets wiped out. Or under subsection 4 of section 216, everything gets wiped out.
One after the other, I shall take your lordship. First judgment, which I would like to draw my lord's kind attention is, have a look, kindly turn to paragraph 20.
Yes, sir.
Well, before I take your lordship to paragraph 20, it would be useful for me to draw my lord's kind attention to paragraph 19, because their lordship would refer to section 386.
Yes.
Well, let the prosecutor bring to your lordship's notice a single judgment which would indicate,
yes, sir,
that the evidence that has been recorded earlier or the proceedings which came to be recorded earlier,
yes, sir,
the altered or the amended charge would keep the evidence that has been recorded intact. I am happy. The courts would say no. Have a look at section 300, paragraph 19 at internal page 109.
Yes, sir.
My lord, I shall just
109.
skip 386.
Yes, sir.
Take your lordship to paragraph 20.
Para 20.
Para 20 at page 110.
Yes, sir.
The scope of the power of the appellate court, my lord, as my lord has pointed out, is the
Yes.
power under section 386.
86.
386. To direct a retrial has come up before this court for interpretation in several decisions. Here, instead of retrial, what the language that is used under section 216 subclause 4 is a new trial. Instead of retrial, what is used is a new trial.
New trial.
The judgment of a constitution bench in Kakate versus the state of Maharashtra has dealt with the issue extensively. In that case, the appellant was tried before the judicial magistrate for the offense of rash and negligent driving while under the influence of liquor, thereby causing the death of one person and injuries to four others, and for offences under the Motor Vehicles Act. The trial judge held that the evidence was not sufficient to prove that the appellant was driving the motor vehicle at the time of mishap and acquitted him of the offences under the Motor Vehicles Act and the Penal Code. But he held that the evidence established that the appellant had consumed illicit liquor and committed an offence punishable under section 66 subclause B of the Bombay Prohibition Act. The appellant was convicted and sentenced to imprisonment for 3 months and was directed to pay a fine. On appeal, the Sessions Court set aside the order of the trial court and ordered a retrial on the ground that a fair and full trial had not taken place. The revision was summarily dismissed by the High Court, which led to this appeal. He is satisfied, but here also the trial court must be satisfied.
Yes.
If my lord is persuaded to accept my submission, is nothing short of a retrial, ordering retrial, because he says evidence has to be recorded under section 230 and 231. The above extract emphasizes that a retrial would not be ordered unless the appellate court is satisfied that the court trying the proceedings had no jurisdiction. Number one, the trial was vitiated by serious illegalities and irregularities or on account of a misconception of the nature of the proceedings, as a result of which no real trial was conducted. The prosecutor or an accused was, for reasons beyond their control, prevented from leading or tendering evidence material to the charge, and that in the interest of justice, the appellate court considers it appropriate to order retrial. Another feature which emerges from the above decision is, etc., is that an order of retrial wipes out from the record the earlier proceedings and exposes the present accused to another trial. It is for that reason that the court has affirmed the principle that a retrial cannot be ordered merely on the ground that the prosecution did not produce proper evidence and did not know how to prove the case.
Yes.
But although this may be under section 386, power of the appellate court.
Appellate court.
What is it that the court is required to follow? An alteration is made.
Yes.
An amendment is done.
Yes.
A fresh charge is framed.
Yes.
Under section 216 subclause 4.
Yes.
Well, what is the procedure which the court is required to follow after that addition or subtraction? Parallel, despite the fact, well, I shall presently take your lordship under section 216.4 also, it wipes out, probably that would cut at the root of the... But the second judgment on which I am placing reliance is, again, that of the Supreme Court. Let kindly go to 2017, volume 12, Supreme Court cases 699.
Yes, sir.
Kindly turn to paragraph 12 and 30. But there it is de novo trial. Here it is de novo trial. There it is retrial.
Retrial.
In one case it is new trial.
But all under section 386.
No. I shall take your lordship too.
Hello. Yes.
Certainly.
Those are the
what I am inviting.
Yes.
Well, I am just drawing an analogy. Although the appellate court has got vast powers, still it can't be exercised blindly and in the most mechanical manner.
That is true.
That is what...
wiping out the entire trial and saying a retrial has to be conducted. Exceptional circumstances where
that is why,
circumstances exist first.
Is it not going to cause prejudice to the accused?
True. Yes.
But kindly have a look at paragraph 12. The de novo trial means a new trial ordered by an appellate court in exceptional cases when the original trial failed to make a determination in a manner dictated by law. The trial is conducted afresh by the court as if there had not been a trial in the first instance. As in this case, when he orders a new trial, under section 230 and 231 record the evidence, as if nothing has happened earlier. Undoubtedly, Well, the appellate court has the power to direct the lower court to hold a de novo trial. But the question is when such power should be exercised. As stated in this case, so and so, an order for retrial of a criminal case is made in exceptional cases and not unless the appellate court is satisfied that the court trying the proceedings had no jurisdiction to try it, or that the trial was vitiated by serious illegalities or irregularities or on account of misconception of the nature of the proceedings, and on that account, in substance, there had been no retrial, or that the prosecutor and accused was, for reasons for which he had no control, prevented from leading or tendering evidence material to the charge. And in the interest of justice, the appellate court deems it appropriate, having regard to the circumstances of the case, that the accused should be put on his trial again. An order of retrial wipes out from the record of the earlier proceedings and exposes the person accused to another trial, which affords the prosecutor an opportunity to rectify the infirmities disclosed in the earlier trial, and will not ordinarily be countenanced when it is made merely to enable the prosecutor to lead evidence which he could but has not cared to lead, either on account of insufficient appreciation of the nature of the case or for the other reasons. This court in the state of UP was so and so, while dealing with the question whether the High Court should have quashed the trial proceedings only on account of declaration of the legal position made by the Supreme Court concerning the procedural aspect about the cases involving offences under so and so, a de novo trial should be the last resort, and that too only when such a course becomes so desperately indispensable. It should be limited to the extreme exigency to avoid a failure of justice. Observing that any omission or even the illegality in the procedure which does not affect the core of the case is not a ground for ordering a de novo trial in the state of Madhya Pradesh, etc. In this case, the trial has already commenced.
True. Yes.
Now, during the pendency of the trial, my lord, the trial, as my lord is aware, continues till the judgment in the case is delivered.
Yes.
It was at that stage, my lord, they would come out with this additional report. And on the strength of this additional report, my lord, the charges came to be altered. But then, when once the charges are altered, in exercise of the powers clothed upon the court under section 216, subclause 3 or 4, the procedure which the court is required to follow is not under section 230 and 231, but it would be only under section 217.